In this video, I'm going to show you the 5 critical clauses that need to be in your LLC operating agreement, and I'll walk you through the real examples of what happens when they're missing. Stick around because the 4th one on this list has saved my clients millions of dollars in legal fees. I'm Santiago Cueto, board-certified international business law expert and best-selling author. I've drafted hundreds of LLC operating agreements over my career. Today, I want to share the most important lessons I've learned so you can protect your business from the beginning. All right, here's something most entrepreneurs don't realize until it's too late. Your LLC operating agreement isn't just a formality, it's the constitution of your business. And just like a country without a solid constitution can fall into chaos, a business without a proper operating agreement is a lawsuit waiting to happen. Let me tell you about a recent case. 2 friends, let's call them Marcus and David, they started a software development company together. There were 50 partners, best friends since college, and they trusted each other completely. So when their lawyers asked about adding specific decision-making clauses to their operating agreement, they waved it off. We'll figure it out as we go, they said. That trust cost them everything. 3 years later, they disagreed on whether to take on a major investor. Marcus wanted to grow aggressively. David wanted to stay independent. Their operating agreement said nothing about how to resolve the deadlock. With equal ownership and no tie-break mechanism, they were stuck. The disagreement escalated, the investors walked away, and eventually, they had to dissolve the company and sell the assets at a fraction of their value. Now, this brings me to the first critical clause you absolutely need. Your operating agreement must clearly define who makes what decisions and how. This isn't just about day-to-day operations. It's about the big stuff that can make or break your company. There are typically 3 tiers of decisions in an LLC. First, routine operational decisions that managers can make unilaterally. Things like hiring employees under a certain salary threshold or signing contracts below a specific dollar amount. Second, there are major business decisions that require a vote, like taking on debt over a certain amount, entering new markets, or changing the company's core business model. Third, there's fundamental changes that might require unanimous consent, like amending the operating agreement itself, selling the company, or admitting new members. Your management structure should also address what happens in a deadlock situation. Can you bring in a neutral third party? Does one person have a tie-breaking vote? Can members trigger a buy-sell provision? Whatever mechanism you choose, it needs to be in writing before you need it, not later when it's too late. Now, the second essential clause covers money, both going in and coming out. You need crystal clear terms about initial capital contributions, additional capital calls, and how profits get distributed. Now, here's where things get messy if you're not careful. Let's say you and your partner start an LLC. You contribute $100,000 in cash, and your partner contributes equipment worth $100,000. Now you're both 50% owners. A year later, the business needs another $50,000 to stay afloat. You have the cash, but your partner doesn't. What happens to your ownership percentage if you're the only one who can contribute? Without a clear clause addressing this, you're only headed for conflict. Does your ownership percentage increase? Does your partner's decrease? Can the company force your partner to contribute or face dilution? What if neither of you can contribute more? Can you bring in outside capital? The distribution clause is equally important. Will you distribute all profits annually or retain some for growth? Do distributions have to be proportional to ownership, or can you get creative? What happens if the company needs to retain earnings for an unexpected expense? And this happens a lot more often than you think. Now, before I get into the third clause, if you're finding this valuable, do me a favor and hit that like button. It helps more business owners discover this content and protect themselves from costly legal mistakes. And make sure you're subscribed because I share strategies like this every week that can save you thousands in legal fees down the road. Now, the third crucial clause is the buy-sell provision. And this is the one that saved my clients the most money and headache. The clause is essentially a prenuptial agreement for your business. That's right, a prenuptial agreement for your business. It specifies what happens when a member wants out, becomes incapacitated, gets divorced, or dies. At minimum, your buy-sell provision should address triggering events like death, disability, divorce, bankruptcy, or simply a voluntary exit. It should specify a valuation method, maybe book value, a multiple of earnings, or an independent appraisal. And it should outline payment terms. Can the remaining members pay over time, or does the company need life insurance policies to fund a buyout? Some of the best buy-sell provisions I've drafted include right of first refusal clauses, meaning that if one member wants to sell their interest, the other member gets the first chance to buy before any outsiders can come in. Others include shotgun clauses, where one member can name a price and the other member must either buy at that price or sell at that price. It forces both parties to be reasonable. Now, the fourth clause defines duties and obligations of members and managers. By default, members of an LLC owe each other a fiduciary duty of loyalty and care, but you can modify these within your operating agreement, and you should be explicit about what's expected. The duty of loyalty generally means you can't compete with the LLC or take business opportunities that belong to the company. Makes sense, right? But what if one of your members runs multiple businesses? I had a client who was part of an LLC that provided marketing services, but he also owned a separate web design company. Now, without a clear carve-out in the operating agreement, his partners could have argued that he was violating his duty of loyalty by running a related business. So what do? We added language that specifically permitted members to engage in other ventures, even in related fields, but as long as they weren't directly soliciting the LLC's clients. You should also address non-compete obligations. This is a huge one. Pay attention. If a member leaves, can they immediately start a competing business? Can they hire away your employees? Can they contact your clients? These questions need answers in your operating agreement, not during a heated dispute after someone's already left. Now, the fifth and final critical clause is dispute resolution. This one's simple, but it's powerful. Litigation is expensive, time-consuming, and public. Your operating agreement should require mediation or arbitration before anyone can file a lawsuit. I represented a real estate investment LLC where two members had a falling out over how to handle a distressed property. Their operating agreement required binding arbitration. So instead of spending 2 years and hundreds of thousands of dollars in court, they had a 3-day arbitration hearing, got a decision within 30 days, and they moved on with their lives. The total legal cost was about 1/10 of what litigation would have cost. Now, your dispute resolution clause should specify the process. Maybe it's mediation first, then arbitration if mediation fails. It should name the organization that will oversee it, like the American Arbitration Association. That's the biggest one and probably most reputable. And it should address who pays the cost and whether the prevailing party can recover attorney's fees. Look, I know how operating agreements aren't the most exciting part of starting a business or even a video, but I've seen too many entrepreneurs lose everything because they skipped this step or used a generic template or ChatGPT without thinking it through. Now, these 5 clauses, management structure, capital contributions, buy-sell provisions, fiduciary duties, and dispute resolution, they're your insurance policy against the worst case scenarios. Now, if you found this video helpful and want to protect your business the right way, hit that like button and subscribe to this channel. I break down complex concepts every week to help entrepreneurs like you avoid expensive mistakes and build stronger companies. I'm Santiago Cueto, your Florida business law attorney. Click on the video I've linked here, and I'll see you in the next strategy session.